My Lord, indeed, as I've said, or as we've discussed in chambers, we have an instruction to move an application. Unfortunately, I just got failed by my device here, and I'm informed that there are no plugs that are closed. It's unfortunate. This is like 2024, but we find ourselves in this situation. So I'll just work around with what I have and rely on my memory. Yes. We rely on these devices. So the application that we're going to move, my Lord, it's literally to safeguard the interest of accused number 7, which is primarily the right to have legal representation. So without that right, nothing can move. Trial or pre-trial, absolutely nothing can move, because our responsibility, we don't owe him only the responsibility to protect his interest, but we also owe the responsibility to this court as officer of the court for the administration of justice. So that's why that aspect should be moved first before anything else. And as such, the accused previously tried to move this application. Last time, there was something, obviously, it excited the media. But in that endeavor, he was simply saying, my Lord, I can't do anything without consulting with my lawyers. And possibly, in the treatment that I'm receiving, you might not have accused number 7 in future. Either because of psychological problems, because we need him, all of him, physical, mental, and everything. So if he is kept by the state machinery, which is the correctional service, in the manner that obviously I'm not going to deliberate, it's there in the papers, it's going to be deliberated in due course, would have wished to deliberate today. We might not have him mentally intact. So, and that itself, my Lord, it's something that needs to be dealt with expediently. And we also responded to that expedient, to that expedient requirement of that type of endeavor. So what we did, we consulted with him several times with the restriction that are imposed by the correctional service, and some of the restriction obviously ended up in some of us catching flu, because we consulted him in extremely cold conditions there at the correctional service center. So we don't want to have him not here in court and his legal representative because of the conditions there. So we drafted an application, founding affidavit, served on the state, served on the prosecutor, served on the correctional service, served on the head of correctional service, because some of the prayers that we seek, it will need the court to order them to do or not to do certain things. Now, what happened in chambers was some sort of like an engagement as to whether this court would hear this application or it should go to some court, motion court, or whatever court that specializes in that. Our view is that this is the court that specializes in what we are about to do, because it has nothing to do with anything else but his right to a fair trial. And a fair trial is not him taking the stand and start giving testimony. A fair trial includes legal representations. So if that is threatened or has been violated, this court itself must intervene. That's why this court can intervene, that now the correctional service, as they are here, because this is not for Simambuli, this is the court, can order them to remove the shackles. He is in shackles now. As you see him as a criminal, but no, he's not. He's an accused person. He must enjoy the presumption of innocence. So when you see someone being brought like this in court, you have an impression that here is a villain in court. We don't want that. We want your lordship to see him as all other accused that you see here. So that on its own does not need some head of correctional service he is before your Lordship, that you can do. Does not need us to go to any other court. Literally, your Lordship, with utmost respect, can say that this creates a bad perception to the accused person, that there is accused person that are seen as criminals, there is accused person that are seen as accused in a true sense. So that is part and parcel of what is going to be the motivation why no any other court but this one must hear this application. But because, my Lord, administratively we had challenges that we could only serve this application yesterday at 3. What that means is that inevitably, even if your Lordship wanted to hear this application, it's practically impossible, because we raise serious issues, legal points that need to be ventilated. And that's why in the service of the application we omitted a notice of application or a notice of motion, deliberately, in a sense that there was no one that would have been able to come here. But as a matter of courtesy and to avoid ambush, serve the affidavit. And we say that in our notice of application, we were going to obviously seek directives. If we had had enough opportunity to deal with this application, would have prescribed the time frame, because there's no rule in this particular court that says that this one must file the application after 10 days, not Rule 612. That's not how criminal proceedings are conducted. Try to fashion or find the best possible solution under the circumstances to protect the right of the accused. We don't become the slave of the rules that are not applicable. So we would have prescribed and motivate why we prescribe as such.